Yes, so my name is Adeline Chelagat Kipto, and I shall be the moderator for this session. I am a finalist. I'm waiting to graduate. So today's session is a very important one. This is the second day of commemorating our Constitution at 15 years. And today we are joined with a wonderful, wonderful panel of five incredible individuals. And allow me to introduce them and then introduce our discussant today. Today, our panel is composed of, when we start from this side, we have Victory Kanana. Victory Kanana is also awaiting to graduate. She is a prolific writer. She is a scholar. She is a profound researcher. On this side, we have Mr. Jimmy Wambua. Sorry, Victory will be dealing with labor relations, that is Article 41. We have Mr. Jimmy Wambua, who shall be dealing with Article 14, the protection of right to property. Jimmy, I believe, is going to third year. We also have Ms. Velma Hazel, who will be dealing with Article 39 on the freedom of movement and residence. Velma will be going to fourth year. Next, we have our co-authors, that is Ms. Debbie Abishag and Ms. Shakaina Onditi, who are dealing with Article 38. You're going to third year. To fourth year, yes. And for our discussant today is Mr. Samuel Kimeu, who is an advocate and a seasoned governance expert with vast experience in anti-corruption, accountability, and human rights. Since January 2020, he has served as the executive director of Africa's Voices Foundation in Nairobi, where he leads efforts to promote citizen participation and governance through innovative media and data-driven platforms. He holds an LLB from the University of Nairobi and an LLM in International Human Rights Law from the University of Notre Dame in the USA. He's a fellow of both the Law Society of Kenya and the East Africa Law Society, and is associated with the Solicitors of England and Wales. Before he joined the Africa's Voices, Samuel was the Executive Director of Transparency International Kenya from 2010 to 2020, and earlier served as the governance specialist at the Embassy of Finland in Nairobi. He has lectured at Kenyatta University and has led the International Commission of Jurists. So these are among many, many things that Mr. Kimeu has done, and today he shall be our lead discussant. For the members of the in this members of the community as well as students who have joined us today, I want to invite you and welcome you so much. Please ensure that you keep your phones on silent and ensure minimal movement as the panel proceeds. The session will estimatedly take around 1 hour 30 minutes to 2 hours should we extend. So I believe we shall have around 40 minutes for the panel and maybe some 20 minutes for the discussant because of the back and forth. And then we shall have around an hour or 30 minutes or 40 minutes. This will depend with the questions that we will have, right? So at this point, I would like to unset the panel and we can begin. So I think I will now hand it over to Mr. Kimeu and let us begin. Thank you.
Thank you. Thank you very much, Adelaide, for that introduction. It's a pleasure to facilitate this conversation, and I hope you can hear me. I can see my panelists. I can't see the audience, but that's fine. For reasons that I couldn't avoid, I couldn't travel down to be with you in Kabarak, but I am really honored to get this invitation and to facilitate this conversation. It's been 15 years since our constitution was promulgated, miaka 15, mwongo moja na nusu. Ina maana kwamba tumekuwa na wakati mzuri wa kuweza kutathmini hatua ambazo tumepiga kuanzia tulipo tengeneza katiba yetu kwa sasa hivi, na wenzangu ambao wako na sisi mbele yenu watakuwa na nafasi ya kuweza kuchambua vipengele 4 hivi za haki ambazo katiba yetu imetuhakikishia. Kwa hivyo nafikiri tutakuwa na dakika 40 kama vile tumeelezwa, na katika kila kipengele tutachukua muda wa dakika 10. Kwa hivyo wenzetu, the panelists, you'll have 10 minutes to expound on your article, and I will be asking questions as we move along. But I'll take this opportunity to start us off by basically giving the floor to our first exposition, that is Ms. Debbie Abishag and Ms. Shakina Onditi, to speak to us about Article 38 on political rights. You have the floor, ladies.
Thank you. Hamjambo. Yeah, so nitakuwa nazungumzia kipengele cha katiba cha 38, Article 38, na inaongelelea haki ya kujihusisha kisiasa, political rights. Sasa haki hii ukiangalia katiba, first of all, it provides for haki ya kujihusisha na chama cha kisiasa. So right to join a political party. Na inapatia kila mwananchi, ukiangalia maandishi ya haki hii katika katiba, ni imeandikwa for every sabbatical, every citizen. So ni haki ya mwananchi. So, inapatia kila mwananchi kwanza haki ya kujiunga na chama cha kisiasa, pili haki ya kuwania kiti kwa chama cha kisiasa, na pia kwa any elective position. Tunaweza wania kwa chama cha kisiasa na any elective position. Ya tatu, inapatia mwananchi haki ya kujisajili ili kupiga kura, haki ya kupiga kura kwa siri, secret ballots. Na tatu, inapatia mwananchi, japo utachaguliwa, uko na haki ya kuingia kwenye hiyo kiti. Sasa nitazungumzia historia ya haki hii hapa Kenya. Hapo awali, wakati wa ukoloni, Wakenya wa Afrika hapa Kenya walikuwa wametengwa, hawakuwa na haki hii ya kujihusisha kisiasa, hawakuwa wanaweza piga kura, hawakuwa wanaweza wania kiti chochote, walikuwa wametengwa kabisa. Na hata Wakenya ambao walijaribu kuunda vyama vya kisiasa kama vile Hari Thuku, hizi vyama vya kisiasa zilidhulumiwa kabisa na hatimaye zikapigwa marufuku. So they were ultimately banned after a lot of suppression. Tukiendelea, hata wakati ambapo Waafrika walipata nafasi kujiunga kisiasa, walipewa vyeo vya chini zenye, if you look at it, they couldn't really make any changes. Na wakoloni bado walikuwa na hiyo uhuru ya kusema wewe utabaki, wewe utatoka, hata kwa hizi cheo ambao Waafrika waliweza kupewa katika in governing the citizens. They were given very inferior roles, and ultimately it was the colonialists who had the discretion to choose who will stay, who will go. So tunazoona kuwa Waafrika hapo awali hii haki ilikiukwa kabisa. Nakumbuka hii ni haki ambayo I can say it goes to the core of our people, of the Constitution. It is a right to choose your leader. Ndio tunasema the people shall, watu wakisema hivyo. It is what gives you that voice in your society, in your community. So tukienda wakati Kenya ilipata uhuru, watu wengi walikuwa na matumaini kuwa vitu vitakuwa tofauti. Lakini hiyo si kila ambacho kilifanyika. Bado kuna watu walifungwa nje, na hiyo political rights ilikuwa a space of very few elites. Sasa unapata kwa mfano tukielekea uhuru tulikuwa na two major political parties, KANU na KADU. Lakini by 1963 already hizi political parties zilikuwa, hakukuwa na an opposition. Wale watu wa KADU walienda wakaingia KANU. Na ukiangalia historia yetu hadi saa hii ni kitu bado inatendeka. Unapata watu wanapiga kura, wanasema wanataka hawa watu, lakini unasikia handshake, sijui nini. Ule mtu umepigia kura, unaweza pata umepiga kura ukijua nataka hii na hii, lakini unapata hiyo like public participation inakuwa repressed in a way, kwa sababu voting ultimately is the voice of the people. So you vote for this person, but using the back door, as yesterday Honorable Gitobu Imanyara was saying, in boardrooms, you find the opposition has been co-opted into the government. So this really, it reduces that democratic space, because now the opposition haifanyi kitu inafaa kufanya. Pili pia naweza sema, vile tu ilikuwa mwanzo, unaona political parties zilikuwa very KANU na KADU. Ulikuwa unaona most ethnic groups zenye ni major zilikuwa KANU na zenye zina minor zilikuwa KADU. Na baada hata sasa hizi ukiangalia vyama vya kisiasa hapa Kenya, unapata bado ziko ethnically affiliated, zimejigawanya kiukabila kama naweza sema hivyo. Aya, sasa nikiendelea, sasa baada ya KADU kuingia KANU tulikuwa tuna hiyo chama moja, na baadaye kukakuwa na matatizo hapo ndani ya hiyo KANU. Sasa watu kama Oginga Odinga wakajaribu kutengeneza vyama vipya vya kisiasa, na alikuwa anajaribu kutengeneza Kenya People's Union, KPU, na hii iliendelea 1966 to 1969. Hapa ndio tulikuwa na hii multipartyism. Lakini hata hapo kwa hii very short period zilidhulumiwa kabisa hii chama chake, na hata alipoenda kuregister, for example, unapata taasisi za serikali, state institutions, kama vile Registrar of Societies, walikuwa wanakataa kuwasajili. So hata then hii right to form a political party ilikuwa extremely hard for them to be registered and to be recognized as a political party in Kenya. Wakati wa Moi, kama tunavyojua, 1982 yeye repeal the Constitution, alibadilisha kufanya Kenya by law, kisheria, sasa ikuwe a one party state. Sasa sheria yetu ilikuwa inasema sisi ni a one party state, hakukuwa na hiyo provision ya multipartyism. Na hata unaona katiba yetu saizi inasema kupiga kura itakuwa kisiri, by secret ballot. But hapo awali ukiangalia 1986 watu walipiga kura wakipiga mstari, mlolongo voting. Sasa hiyo ilikuwa inafanya kunakuwa na uoga. Utapigaje kura na watu wanajua unapigia huyu kura, unapigia huyu kura, wanaweza kutafuta baadaye wakusalimie. Sasa haukunaweza fanya, ilikuwa inaleta uoga. Na pia huyo wakati kulikuwa na kitu inaitwa snap elections. Moi anaweza amka aseme kama baadaye hiyo 1982 attempt ya hiyo coup, anaweza sema alisema tutakuwa na elections na hii date. Lakini sasa hizo unaona Constitution iko very specific, periodic, na pia provide a specific date every Tuesday. Sasa haiko tu kwa uhuru wa serikali kuamua hii ndio itakuwa siku ya kura, ya itakuwa siku ya kura. Sasa hii ndio historia yetu yenye ilituelekeza kwa katiba ya 2010. Sasa niko na co-author Shekaina atawaelezea vile tumekuwa tukiendelea. Asanteni.
Asante. Kabla Bi Shekaina hajachukua huo muda, ningependa tu nizungumzie jambo moja ama mbili, kuangazia kwamba tunaweza ili tuweze kudhibiti muda wetu vizuri. Nafikiri dakika zenu 10 karibu ziishe, lakini nitawaongezea dakika moja tu ili muweze kumalizia uchambuzi wenu. Na nikosoe kidogo, ulimzungumzia Bwana Raila Odinga kama ndiye mwanzilishi wa chama cha KPU. Alikuwa ni babake Jaramogi Oginga Odinga, na pengine Madam Shakina akizungumza anaweza zungumza vile anavyoona jambo la the cost of elections, kwamba chaguzi zetu zimekuwa ghali sana, zinafungia watu wengine nje wasiweze kushiriki katika haki hizi. Pia kuna jambo la udanganyifu, jambo la violence, lack of transparency na mambo kama hayo. Bi Shakina, uko na dakika kama 2 hivi 3 kuweza kuzungumzia jambo hili. Asante.
Nitaanza na kuzungumzia gharama ya uchaguzi. Nitaanza na kuzungumzia kuhusu gharama ya uchaguzi na jinsi hiyo inafungia some Kenyans out. It's locking them out of participating in their political rights. Katika gharama ya uchaguzi tunaongelea campaign costs. Tunaongelea campaign costs. Kunafaa kukuwe na election campaign financing regulations ambayo bado haijakuwa implemented, bado tunangoja. Sasa juu haiko hiyo, the cost of campaign, it keeps on getting higher and higher, higher and higher and unregulated. Therefore, it makes citizens shun away from vying for elections because you feel like you can't afford the cost of campaigning. Therefore, it's locking you out, not by law, but by the mere fact that you see the election campaigns, like the people spending all this money on campaigning. You feel like, I don't have that money, so I can't vie. So it's limiting your political participation rights to your right to vote. It's locking you out from trying to be voted for. Another fact that this social economic challenge that can be seen is forming of political parties. Another form of political participation ni kuunga na kujiunga na kuanzisha political party, but ndio utengeneze a political party, you have to, your application has to be accompanied by an application fee, and that application fee in reality it's too high for a normal Kenyan citizen. For example, for a provisional registration, you need to have 100,000 Kenyan shillings. And for full registration, you need to have 500,000 Kenyan shillings. In reality, for a normal Kenyan citizen, where is this money coming from? In a country plagued by unemployment, plagued by poverty, majority of the population living below poverty lines, how are you supposed to get that money to form a political party? So therefore, these challenges and these social economic issues are limiting political participation to only the right to vote. It locks you out from the right to forming a political party, the right to vie for election. And when talking about the lack of transparency, I feel this is very well seen in the 2017 election, where a whole election was nullified due to lack of transparency. You can't talk about the implementation of the Article 38 without talking about the IEBC, since the IEBC is charged with the mandate of providing and implementing the promises of Article 38. So therefore, if the IEBC is inefficient, therefore the implementation of these rights will also be inefficient consequentially. I don't know if time will allow for me to dive deeper.
I'll give you 1 minute to just complete your thought, and then we give you the chance to others. Thank you.
Okay, thank you so much. On the IEBC, apart from the lack of transparency and the lack of Yeah, the lack of transparency, which leads to voter apathy, also like in inhibiting and limiting the right to vote, because you feel if I don't know if I am voting for who I am voting, but I feel like another person is it's not who I voted for, and another person came through the back door means, how am I supposed to vote again? They'll do what they'll do. It leads to voter apathy due to this lack of transparency. Another thing is like the inefficiencies within IEBC and the appointment of commissioners also inhibits and limits these rights of voting, the right to vote, as seen in Banisa constituency, where they couldn't have by-elections because there was no commissioner. Their MP died, they couldn't elect a new one due to the lack of commissioner. Also in Kisa East, where after the stabbing of their MCA, they couldn't hold by-elections. I'll conclude from that.
Thank you. Thank you very much, Debbie and Shekinah, for that exposition. I think it covers quite well the article that we are talking about, the right to political participation or political rights. I think there are just 2 or 3 highlights that would be important for me to make before we move to Velma, who is going to be presenting on Article 39. And these are that even though we've made progress in terms of political rights, there are still challenges that remain that need to be addressed. And the 2 able ladies have highlighted some of these challenges. What hasn't been delved into is the gender dimensions of the challenges facing this right. That when costs are prohibitive, not just costs to do campaigns, but also costs to register to be cleared by political parties as candidates, it tends to exclude those who cannot afford, and women suffer in the same in the process. When it comes to cheating, violence, and lack of transparency, again, we have the challenge that this tends to exclude those women and people who are living with disabilities, and those who generally would not want to be in a place where there is turmoil. So what then this does is that you have suppression of the vote. There are many other things we can talk about, but perhaps we can leave them for later. And then we give the space to Hazel Velma to give us her exposition on freedom of movement and residence. And Hazel, you have 10 minutes.
Thank you, Mr. Kimeu. My name is Velma. I am dealing with Article 39, which pertains the right to freedom of movement. It has 3 clauses. The first one, which states every person has the right to freedom of movement. Every person has the right to leave Kenya. And the third one, which is accorded to every citizen, has the right to enter, remain in, and reside anywhere in Kenya. So this right is mainly divided into 3 phases: the post-colonial phase, the colonial phase, or the pre-colonial phase. So pre-colonially, before wazungu wakuje, tulikuwa tunaweza move ama kutembea. Our movement was not restricted. We were able to engage in long distance trade. For example, the Kambas were long distance traders, and movement was only disrupted by external factors like warfare. This all changed when the British declared Kenya a protectorate in 1895. When the British came, our movement was deeply restricted. This was with laws that they introduced, like the Crown Lands Ordinance, which Jimmy will expound on. The Crown Land Ordinance segregated African land and the White Highlands, as they called, which were occupied by settlers. And now Africans were required to carry permits to enter districts such as Nairobi. And this was not the only thing. I don't think sisi kama Gen Z tunaweza relate, lakini members of the community watawaambia wazazi wao ilibidi wamebeba kipande ili kujitambulisha kwenda vitu kama kazi ama kwenda tu palipopote, ulikuwa unahitajika kubeba hiyo kipande chako ambacho kina kutambulisha. So this was how the movement was restricted with various laws. And then now we proceed to the independence period, which the freedom of movement was included into the independence constitution as a fundamental right and freedom. But the only problem was not problem per se. It included restrictions. The freedom of movement could be restricted or rather regulated in cases of public order, public security, and public health. And it gave so much power to even the president, because the president, under the Preservation of Public Order Act, was allowed to restrict freedom of movement if he found reason of public security, which was not necessarily good, as I'd like to say. Professor Ambani talks about this in his book, where the limitations of freedom of movement, of fundamental freedoms, had these clawback clauses of limiting our fundamental rights by using these blanket excuses like preservation of public order, preservation of public security. It's like they're giving you a right, instead of promoting this right, they're protecting it rather, or like they still have the power. So this all changed during the post-colonial phase, especially with the 2010 Constitution, because now our right is just constrained, not constrained, it's only those three clauses. It's not like the Independence Constitution where we had, the right of freedom of movement can be restricted through this and that. This is because in the Independence Constitution, the right to freedom of movement can only be limited if under the subject of Article 24. So if it is prescribed by law, if it is necessary and proportionate, if it is reasonably justifiable in a democratic society. This was looked at in the case of Law Society of Kenya versus Mutiambai, where the citizens challenged the curfews imposed during COVID-19 as restricting their freedom of movement. But the court, yes, acknowledged that their right to freedom of movement was restricted, but said it was necessary and proportional because it is justifying public health. Because yes, your right to freedom of movement is being restricted, but we are doing that because there's COVID and this could spread. And this is not the only case that the court has dealt with restricting the freedom of movement. We also have Haki na Sheria Initiative versus Inspector General of Police, where also the citizens, where the government issued or rather directed curfews to be put after the Garissa terrorist attacks. The Court of Appeal concluded that yes, they had restricted their freedom of movement and they could not interact and do business, but this is because of the terrorist attack that had happened. So that's how the court is balancing restricting the freedom of movement and public order. Now, this is different from post-colonial times or even the post-independence constitution, where the government had excess power, because now we have to check under Article 24 if it meets the criteria under Article 24. And another thing that I'd like to applaud, or rather, the Constitution about, is even articles such as Article 21, which require the government to address the needs of vulnerable communities, such as refugees, because this is not really talked about. So in Kituo cha Sheria initiative versus Attorney General, the government had issued a directive for refugees to be, for refugees who live in urban areas to be relocated to Dadaab and Kakuma, and to stop registration and reception of refugees in urban areas. And the High Court concluded that this limits the right to freedom of movement of refugees, and also highlighted that although Article 39.3 is only accorded to citizens, this does not limit the movement of refugees. And the Constitution, the 2010 Constitution, is really transformative in a way that even the draftings of Article 2, which allows us to include international commitments into our law and enforce it, even if it's not followed by. So yeah, this has really helped us to even recognize refugees, as opposed to a long time ago where we only had the Aliens Restrictions Act and the Immigration Act, which considered refugees as aliens. Yeah, I believe I have concluded my answer.
Thank you. Thank you very much, Velma, for remaining within the timelines. And I think you've done an excellent job in covering this article. Kuna mambo mawili matatu tu ambayo ningependa kuongezea ama kuangazia, ndio wengine waweze kuyafikiria na pengine tuyazungumzia baadaye. Na ni haya kwamba haki ya kuweza kusafiri ama kutoka katika nchi yetu inategemea pia kuwa na vyeti vya usafiri, ambacho kinategemea kuwa na kitambulisho cha kitaifa. Na tunajua kwamba kunao wengi ambao wanasumbuka kupata hivi vyeti. Kwa hivyo hii haki imedhibitiwa kikatiba, lakini in terms of operations and getting it done, there are still challenges that we need to think about. But the question I also want you to think about, and we can come back to it when we have the plenary session, is to think about, this is the intersection between property rights and Article 39 rights. The rights of squatters, people who live on land that they do not own. It's either owned by government or other people. And mostly you find this in the urban areas within our slums. And the problem that arises from what we have come to call, the violent evictions that we see every now and then. Reflect on that, and we'll come back to it at the end of, during the plenary session. So now I want to move to the next exposition, and I'm going to invite Mr. Jimmy Wambua to take us through Article 40, the protection of right to property, the protection of right to property. And I think this is a fundamental right, but it has a particular significance in Kenya because of our history and the colonial heritage from the 1890s to the 1920s and right into the time we get our independence. Bwana Jimmy, nafasi ni yako.
Asante sana. Mtaniwia radhi nitakapoishiwa na msamiati, nitaongea Kimombo na Kiswahili. Haki hii na amini ni mojawapo ya haki ambazo zina mojawapo ya haki ambayo inagusia karibu kila aina ya haki iliyoandikwa katika ambayo iko katika katiba ya 2010. Haki hii ningependa kuieleza katika epochs or a time frame ya 4. Tutaanza na wakati Waafrika walikuwa kivyao bila uhusiano wa koloni. Hapo awali mali ama shamba zilikuwa zatumika kama ilikuwa yatumika pamoja kama kijamii. Kila mtu alikuwa na haki ya kutumia na mnatumia kama jamii. Kwa mfano utapata kwamba Wakikuyu walikuwa wakilima ama Wakamba. Hata ukiangalia wakati huu venye makabila hulima pamoja, utapata wanatoka boma moja na kwenda lingine. Hiyo ndo situation ilikuwa hapo awali. Wakoloni sasa walipokuja, waliona kwamba vile tunatumia mashamba ama mali sivyo. Wanaona kwamba ni lazima we maximize on this land. So wakoloni walipokuja, they enforced privatization through what Ms. Velma had highlighted, or through the Ordinance Act, the Crown Ordinance Act. And Okoth Ogendo terms us as what? Tenants of the Crown. Wapangaji wa Crown, ndio. So walipokuja walilazimisha sasa Waafrika waingie katika what Mahmud Mamdani terms as containerization, kuwapanga katika mipango ya kikabila ili waweze kuwatumia. Sasa Madam Victory will elaborate further on this aspect, on how they were used for the plantations. So this containerization process ama njia ya kwa panga kivyao iliwatoa katika hiyo hali ya kutumia kama jamii. Sasa wamekwama na wakapelekwa sehemu ambazo hawezi tumia kama jamii. Kwa mfano umepelekwa Taru Desert, wengine walipelekwa katika areas ambazo huwa hazina mvua kwa rahisi, ama ukulima haukuwa na mazao ambayo tunaweza sema ni ya binafsi kwa hiyo jamii, enough to serve that community. So they were forced now to go and work in those plantations. They were disenfranchised, yani walipokonywa haki yao kutumia shamba kama community. Sasa iliwalazimu waende walime ili sasa waweze kulipa what we call the rates and rents. Wakati huo waende walipe ili sasa waendelee na maisha. Wakati huo wazungu pia walikuwa wanajaribu sasa kuingiza hii mentality ya privatization. Tuache communal kind of farming or communal kind of access rights. So this forced the communities to now think of an alternative system, and they were complaining. There were obvious complaints, and they were raised in cases such as Olenjoru versus the Attorney General, which was one of the early mojawapo ya kesi zilizoletwa mbele ya Court of Appeal Mombasa, one of the only existing high courts then. Walikuwa wanapinga zile treaties ambazo zilitumika mwaka wa 1908 na 1907. Sasa Wamasai bring more context into this conversation, walikuwa forced ama walikuwa coerced into signing these treaties, giving away their access rights and usage rights, yani haki za kutumia hiyo shamba, haki ya kuwa na nikijaribu kueleza kwa Kiingereza ni kwamba haki ya kutumia hiyo nikijaribu kueleza kwa Kiingereza, usage rights ni kwamba unaweza ingia kwa hiyo shamba ulime, unaelewa. Sasa hizi treaties zilipoletwa ni mojawapo ya njia zilizotumiwa ku disenfranchise these communities. Baadaye wakoloni walipoanza kukaribia kutoka waka introduce what is known as the Swinnerton Plan. The Swinnerton Plan, or the White Hampshire Papers, were used to control land usage for agricultural purposes. Yani ili kulingana na agricultural uses, ningejaribu kueleza walikuwa wanataka kumaximize on kulima. This then now introduced the idea and the mentality of what? Privatization. Now, as the colonial master was leaving, during the Lancaster Conference, and now I'm going to the post-colonial era, when Jomo Kenyatta, and I would like to famously quote, went to the Lancaster House and came back, this particular right now began to be limited in its nature, in that sasa privatization is being forced on the Africans. He said, this is the policy. It was free buyer and free seller. You had to buy from the colonial government. To emphasize, ilibidi ununue kutoka kwa wakoloni. Sasa hii is the, I would call, Africanization of Africanization of this privatization. Is the Africanization of this privatization mentality of property, of owning. So then, the Jomo Kenyatta alisema kwamba hakuna shamba ya bure. Willing buyer, willing seller. After that, the Independence Constitution, ama constitution ambayo ilitolewa hapo awali, ililazimu sasa kwamba ilikuwa na what I would consider as a clawback clause. Kwamba president had grant and dispossession powers. Secondly, kulikuwa na number of misappropriation between that era and between that era of independence and before the 2010 Constitution. A number of lands was misappropriated. So now, when the CKRC Commission came into place, they now forced these particular communities, they took the comments from the communities, of which one of them was the misappropriation of property, even how public property was converted to private property. And this is particularly public lands. Secondly, the CKRC collecting the recommendations from what they termed as the frustrations from the colonial period and the post-independence Kenya, they also noticed that matrimonial property, or rather, was limited by what I would call kasumba kiume, ubabi dume. So the patriarchal form of society for African societies, specifically even in Kenya, limited how women would have access, or would have the right to property protected. So now, this was one of the many recommendations. The third one is that with the 2010 Constitution, the CKRC's recommendations was that there needs to be a process of recovery for these lost lands that were misappropriated. Another aspect is that now, and what I would come to explain after post-2010, is that our relationship with property is changing. Mali inapata new definitions. Kwamba si land pekee, ni hata ni mambo ya IP rights, mambo ya copyrights. Yani ukiunda kitu unaweza register IP rights, including stocks, securities. This yani hizi ni vitu ambazo unaweza nunua na pesa uka invest. It's an investment. These particular things are now being recognized. It's the changing relationship of property now with the 2010 Constitution, and what the CKRC recommended is that we need to acknowledge these particular properties. And the key takeaway for me, particularly for Article 40, is that it's not, it's one of the many articles that has, would call a limitation or a clawback, in that it has it has its own chapter 5, part 1, on Article 65, limits how foreigners can own land, because this was born as a frustration of the colonial relationship that we had with those foreigners that came. 99 leaseholds were then introduced in the new constitution, and we completely removed the 999 leaseholds. Yani, kusema, unaweza kuwa mpangaji Kenya, miaka 1999, ambayo kusema ukweli mababu zenu, mababu hao koloni washaenda. So when we think about how this safeguard came into place, it was born as a matter of the colonial frustration. Yeah.
Thank you very much, Bwana Jimmy, kwa huo uchambuzi wako. Nafikiri umefanya kazi mzuri. Umekuwa na kipengele kirefu zaidi ya zote ambazo tunazingatia kwa wakati huu, na ambacho kinazungumzia mambo ya haki ya kumiliki mali. Lakini kuna mambo mawili matatu tu ningependa ufikirie, pengine utarudi baadaye kuweza kuyazungumzia. La kwanza, katiba inasema kwamba this right does not extend to property that is unlawfully acquired. Na ukimalizia umezungumzia jambo la wageni ama wageni kuwa na ardhi katika nchi yetu, ambayo inaashiria ama ina bring to mind mambo ya historical injustices. The fact that we have had land that was alienated from our ancestors or our people into foreign hands, and that land never quite came back to the people. And then we have political elites who have acquired land, used their political positions to acquire land over time, whether it is public or private land. That still remains an issue that we have not yet resolved. And we had the Ndungu report on illegally acquired public land that still remains unimplemented, even though it remains, for those who are studying law or aspiring to practice law, it remains a reference document for anyone who is doing conveyancing, because it remains the law that public land cannot be alienated. And yet we see every day, as the EACC is also recovering that which has been acquired previously, we still see even today more land being taken away from our public institutions. But there's also the fact that you have land that is not in its description strictly public land. You know, you have a lot of independence era people who donated land for public utilities, schools, hospitals, and you still have a lot of that land that has never been registered either as government land or whatever kind of land. And that remains a major lacuna. That's why we've had problems with land from schools being grabbed across the country and other public utilities. So think about that. And then I think the other issue that arises is, of course, the issue of compensation, fair, just compensation, which I think is an issue that limits this right when it comes to compulsory acquisition. The delays that come in the process of this compensation. I think it's a right that it is a power that has been given to the government to possess land for public purposes, with the caveats that you've just outlined. But we have seen that that doesn't always happen. So let's come to that later. But kwa sasa hivi ningependa tuendelee na mazungumzo yetu. Kipengele cha mwisho, kipengele cha 41 kinazungumzia mambo ya labor relations. Na nafikiri kuna kizungumkuti hapa, na nitamualika Madam Victory Kanana aweze kutoa uchambuzi wake. Dakika 10. Asante.
Asante Bwana Kimeu. Hamjambo? Jina langu ni Victory Kanana, mwanafunzi asiye na kazi ila na deal na article ya
mahusiano ya kazini. So labor relations ni mahusiano katikati ya employer na employee, mfanyikazi na anayepeana kazi. So Article 41 of the Constitution inapa kila mtu haki ya kuwa na fair remuneration, yani kumaanisha unalipwa pesa ambazo zinaambatana na kazi unayofanya, ama malipo yoyote utakayopewa yanaambatana na kazi unayofanya. Pia inapea mtu haki ya kujoin a trade union. Trade union ni chama ambacho kinalingana na kazi yako. For example, kuna vyama vya madaktari, dentist, pharmacist, kuna vyama vya walimu, kuna vyama vingi vinaitwa trade unions. Kwa hivyo una haki ya kujoin a trade union and to participate in the activities of a trade union. Activities za trade unions ni gani? Kurepresent haki zako, kustrike wakati wanataka express their grievances. Easy, all their activities una haki, katiba inakupa haki ya kuparticipate in them. Article 41 pia inakupa wewe binafsi the right to strike. However, the right to strike is quite ina tatizo kidogo kwa sababu ukienda kwa the Employment Act kuna protected strikes na kuna unprotected strikes, which we shall look at as I continue. Sasa nataka tuangalie kuanzia pre-colonial period. Kama vile Jimmy ameeleza, Waafrika tulikuwa tuna deal communally, si ndio? Tunalima pamoja, tuna participate in long distance trade. We did not really have the sort of employment that came with colonization. Alafu here comes colonialists. They come grab our land, wanapeleka watu reserves, and then they introduce taxes, poll taxes, hard taxes. And therefore the Kenyan person has to work so that they can pay these taxes. They are employed in the plantations, employed in the industries that are introduced during colonization. Na pia tunaona kama vile Belma ametuambia, watu ukienda kazi, your freedom ya kutembea kwenda kazini iko limited because you have to carry a kipande to identify yourself. Kwa hivyo, lakini sasa in these employments that came during colonization in the plantations, in the agricultural sector, the industrial sector, there was a lot of discrimination based on racial basis kwa sababu kulikuwa na Asians, Africans, that is the Kenyans, and then there were the white people. Sasa ungepata ya kwamba hawa watu wote wanafanya the same work, same qualifications, lakini malipo ni tofauti. Unapata Asians and Africans are paid lowly in comparison to the white people. Kwa hivyo there was discrimination and low wages. That was one of the issues that faced the employment during the colonial era. And then now due to these challenges, here comes the rise of trade unions. Sasa vile nimeeleza trade unions ni vyama vya kutetea haki za wafanyakazi. So we find people like Makan Singh. Makan Singh alikuwa an Indian person. Tom Mboya, Fred Kubai, Bildad Kagai, they all come up, create trade unions tofauti to represent their people, to represent the Africans, their rights, their right to fair remuneration, the right to work under good conditions because they were subjected to very poor working conditions. However, hivi vyama vili face a lot of opposition from the colonial government. Kwa sababu, first of all, the employers, hawa wenye walikuwa owners of plantations, hawakuwa na recognize the trade unions. So they would articulate their grievances, but nothing would be done really because they were not acknowledging that trade unions are a thing. Also, the trade unions were fought because these same leaders were trade unions, kina Tom Mboya, they were the same people who rose to fight for independence, the nationalism movement. Kama vile kina Abishag and Shakaina have told us, political participation of Africans ilikuwa very pressed by the colonial government. Therefore, they had to find ways to express their rights, and they used trade unions as an avenue to articulate their grievances. So the colonial government ilikuwa inaangalia trade unions, inaona this is an avenue to fight the government. Therefore, walikuwa wana detain, arrest, beat up these union members, basically do a lot of things yenye ilikuwa na discourage watu kujoin trade unions. Na eventually, it can lead to the closing down of so many branches. Tom Mboya talks about these challenges in a paper that he wrote in 1956. Anasema ya kwamba walikuwa wanapungwa, wanapigwa, yani they faced a lot of opposition just because they were trade union leaders and because ilikuwa ina blur the lines na the fight for independence. Now we get independence and we get the 1963 Constitution. Does it change anything? Not really, because the 1963 Constitution inakuja inaleta the freedom of association. And in that freedom of association, it does state that you have the right to join a trade union. However, there is a registrar of trade unions that has the discretion to register or deregister a trade union. Kwa hivyo, really, our trade unions were not free to join and participate in their activities because there were limitations. Also, hii 1963 Constitution haikuwa ina provide for the various rights zenye ziko in our current Constitution. For example, haikuwa inaongea about the right to good working conditions, the right to fair remuneration. It was silent on many of these issues that are addressed under our Constitution. And these issues now zinaanza to come up through civil society organizations, and they come up with the COTU. You know COTU, sindio? The trade union. It is a central organization of trade unions that encompasses so many trade unions under it to represent workers in Kenya. Kwa hivyo, COTU is formed and they try to articulate these rights. And the CKRC, during a drafting of the Constitution, in their draft Constitution now, they address these issues. They address the right to fair remuneration, kulipwa kulingana na kazi unafanya na vizuri. The right to fair working condition, reasonable working conditions, kufanya kazi mahali ambapo panafaa. The right to strike, the right to, kwa sababu strikes during the Moi era was seen as a fight against the government. So they were also very limited. So this draft constitution addresses all these issues and they are adopted into our current constitution. As I said earlier, constitution yetu sahi under article 41 ina provide for the rights to fair remuneration, nimeeleza, right to reasonable working conditions, to form, join, participate in trade unions, na pia to go on strikes. Lakini sasa tunaweza jiuliza kama community members, this right to strike saa zingine ina affect the community. Kwa sababu mara nyingine unapata kama when the healthcare workers strike in a conflict with our right to good and quality healthcare, sindio? That's where the country addresses this by adopting an ILO convention that speaks on essential services. This convention puts a limit on this right to strike. Ya kwamba kuna a person, there are some workers who provide essential services such as medical services, electricity and water supply, ambao wakitaka kustrike, they have to find a balance such that this right to healthcare shall not be curtailed because we want to strike. Lakini pia, this right to strike pia imefinyiliwa kidogo. Ya kwamba unapata kama wakati mwingine walimu wakitaka kustrike, TSC wanaenda kotini, inakuwa the court balances the right to strike and the right of children to education. And most of the time you find that the court upholds the right to children's quality education over the right to strike, which begs the question, is there a right that has of a higher hierarchy than the other? Jambo jingine ningependa kuongelea mwisho ni currently our constitution addresses forced labor and human trafficking. However, this is still a challenge in Kenya currently kwa sababu tunapata citizens wa Kenya wanaenda kutafuta ajira, maybe legitimately they're going to look for jobs, or some are scammed through agencies that misrepresent themselves as study agencies, wanaenda kufanya kazi huko in the Middle East countries. And there they are subjected to torture, abuse because of a system called kafala system. Kafala system ni kwamba employer wako kama tuseme unaenda Saudi Arabia, most of them wanaenda kutafuta this casual labor, right? Employer wako ana sponsor your visa, lakini ukifika huko they confiscate your passport. Wanachukua passport yako ya kwamba huwezi toka, huwezi change an employer. Therefore, it means that you're stuck in a place where even when your rights are violated, where you're subjected to physical abuse, low payment, you cannot change employers, you cannot go back home. And we've even seen cases of people being brought back home as dead bodies, for example, in 2022, because of this subjection to torture. I believe most of us even saw the video that trended, I think 1 year ago. A lady who worked as a domestic laborer was subjected to breastfeeding puppies. Yani the employer anampea hiyo kazi. They are subjected to a lot of physical abuse. And my recommendation would be that the state needs to address this through bilateral agreements with these countries. Sit with the countries, come up with agreements that create a minimum wage, minimum reasonable working conditions. Basically, the state has an obligation to protect its citizens and its citizens' rights under the Constitution. Kuna mambo mengine mengi lakini natumai tutazungumza tukiendelea. Asanteni.
Asante sana Victory kwa uchambuzi wako. Nafikiri umefanya kazi nzuri ya kubaki kwenye muda ambao nimekupatia. Nafikiri tumekuwa tukizungumza kutoka hapa mbele kwa muda mrefu sasa. Nafikiri ni wakati mzuri wa kuweza kuwapatia nafasi ambao wamehudhuria ili kuweza kuuliza maswali kwa wakati huu. Na nitaomba usaidizi kwa sababu siwaoni, ili wakiuliza maswali niweze kujua ni nani anauliza na kuweza kumwelekeza inavyofaa. Kwa hivyo, to our panelists, get ready to receive questions from the audience, and we will start with 3 questions at a time, and let's be very succinct. Let's be very brief and concise, straight to the point, so that we also receive similar responses and we can have more people participating. Twende kazi.
Mr Samuel Kimeu, my name is Calvin. I know you because we've worked a lot on matters of governance in Nairobi. So just allow me to raise, I think, around three questions very quickly. Sir, just 3, very quickly. I'll make them very brief. Thank you. One of them is, of course, on the political rights. And thank you so much, the person who really expounded this and really made us to understand this. I think the question that I think I've really been battling with is the hygiene in our political parties. Because we have actually seen a number of times when you look at the Political Parties Act, and especially in Section 3 of the Political Parties Act, it talks about that the political parties shall promote democracy and inclusiveness. But we've also seen people really misusing this democracy, and especially beginning to campaign for another political party within this particular political party. I think my question, Bwana Kimeu, and the person who led us through this is that how do we cure these bad manners, okay, in our political parties? I think the second thing, very quickly, again, we are talking about repealing of Section 2A of Section 2A, which then gave us the multi-party democracy, right? We've actually seen leaders, and especially in the political parties that have actually won the elections, really trying to buy leaders who are actually on the other side, all right? And we've actually seen this really happening a lot. How do we ensure that then we continue maintaining the spirit of multipartism, even in all these conversations that we're actually having? You have also highlighted the issue of the cost of elections, all right? But allow me to bring something also into the conversation. The election security. We are talking about women and PWDs participating in elections. How can they participate in an election which is marred by violence and by conflict? Then my last conversation then is going to be on the right to enter, to reside, all right? And I think my question is, how do we ensure enforceability of this particular article of the Constitution? And the reason why we are asking that is that all right. Thank you for that. So how do we ensure the enforceability of this particular article? And especially the right of someone to reside in a place. We have always seen this particular right being violated, and especially during the political environment, electioneering period, where sometimes then we have internally displaced persons, and they get to some of these places, and residing in those particular places really becomes a problem because of where they stand politically. How do we ensure that then we have what we call the enforceability of this particular right without really looking at where an individual comes from or which community an individual comes from? Thank you so much.
Thank you. Thank you very much, Calvin. I think Debbie and Shakina have those 4 questions to respond to. They will decide how they respond to them. But before they do that, I will just take 2 more questions from the audience.
So good afternoon, everyone. So my name is Margaret Bilha, and I would like to ask a question specifically to Jimmy because it's under the rights to property, and specifically to right to individual ownership of land. You find that when it comes to ownership of land, sometimes when government have like a project they want to do, they can easily acquire land from an individual. So I wanted to know, to what extent do we enjoy this right to property and specifically land? And also I wanted you to elaborate on the compensation process because it takes long, and tell us the limitations that we have towards this right. Thank you.
Right. Thank you, Margaret. Jimmy, you have your question there. Next.
Jambo. Swali langu ni rahisi tu kwa Shekaina kuhusu bei ama hali ya okay, acha niseme elections campaign, the cost of election campaign. Na pia swali hii ni kwetu sisi wote. Je, tunafikiria kwamba sisi pia tunachangia katika bei ya campaigns kwenda juu kwa sababu tuna ile mtazamo wa kuchukua pesa kwa wanasiasa, ilhali hata hivyo kuna sheria ya elections campaign regulations, finance regulation ambayo ilikuwa enacted 2014 lakini haijafanya kazi. Bado tunaona kwamba bei ya campaigns zinaenda juu. Lakini je, makosa pia inaweza kuwa kwetu sisi tunachangia sisi kuto realize these political rights? Yeah.
Jitambulishe tafadhali.
Mimi naitwa Ekisa Ian.
Asante Ekisa. Nafikiri tuko na maswali 6. Kwa hivyo nafikiri Shakina, wewe ndio umepewa maswali mengi zaidi. Kwa hivyo nitakupatia muda uweze kujibu maswali hayo ukishirikiana na mwenzako Debbie. Ikiwezekana kwa dakika 3 tu.
Haya, asante. Ya kwanza nitajibu swali la pili ambayo niliulizwa na Bwana Kelvin. The repealing of section 2A. So you are asking about if this cooptation, opposition joining parliament, joining government is killing the spirit of multipartyism. That was your question, yes?
Yes, I think I understood the question. I understood the question to ask what we need to do about that buying of other party actors, basically, and you can extend it further to collapsing. I think we've had many of our leaders saying we need to bring our parties together so we form one strong party. I'm just extending Calvin's question, but does that undermine the spirit of multipartism, and how do we deal with it?
Okay, I will answer. Yes, I agree it affects multipartism because when political parties merge, the democratic, the yeah, when political parties merge to form coalitions, in my opinion, I think the democratic space then is reduced. Like the opposition reduces, so the choices are reduced and the options are reduced for the voter then. So I think this affects the democratic space. And yes, it definitely reduces the spirit of multipartism. But at the same time, I would say the Kenyan Constitution provides that for you to be president, for example, you have to have that 50+1. There's that 50+1 requirement. And so there might be need for political parties because of course it is wrong, but the way things are on the ground is that a political party represents an ethnic region in a way in the ground. So I think that the political parties, the reasoning is if we come together and you come from Western, come from Nyanza, you come from Central, if we come together, we might be able to achieve this 50+1 provision. But I agree, it definitely reduces the spirit of multipartism and the democratic space is restricted. Yes, that's how I'll answer.
Thank you. Continue with your other responses.
Okay, on the question on how to ensure the security of women and people with disability during elections. I also wonder that because Article 38 provides that they should not be denied the right without unreasonable restrictions. And I wonder, how do you enforce? We can take them to court, but how do we make IEBC implement the court's decision? Because we know from like the case of Ruben Kigame, the court did agree that IEBC has the responsibility to ensure that people with disabilities, like they have the responsibility to ensure that people with disabilities enjoy these rights, but yet he still wasn't allowed in the ballot box. I don't know how to respond to that question. I would welcome an answer from any of you. And on the question of, are we also to blame on the high cost of campaign? I think we should also bear the responsibility and take the responsibility on our part, but the full blame doesn't fall on us. It is a question of who takes the most responsibility, because after the enactment of the act, it has remained non-operational for quite some time. And there was a case on, after all these years, the rules, the election campaign financing regulation are still to be operational. Is this an IEBC issue? Is it a parliament issue? Because it was taken to court that, and IEBC argued that Parliament has consistently delayed the implementation of these rules, and there's a question of conflict of interest. How do you ask the people campaigning to regulate their own rules on their financing of campaigns? And also in the judgment in that case, it was said that it is unconstitutional to pass the mandate on to Parliament for them to make, and like for the responsibility of these rules to enter into force, because at the end of the day, it is IEBC's constitutional mandate to cap the financing, but the rules also required them to go to Parliament. So it was stated that it should be a public participation thing. But yeah, so to answer your question, yes, we are partly to blame because we do take the money. We should take accountability, but we are not fully to blame because there is also like an interplay of social economic issues, because you are limited to only voters, which makes you open to this voter clientelism, open to this influence by politicians. So I feel like the blame, it can't be accorded to one party, one individual. We all equally take the blame, and I would love to hear your suggestion on how do we move forward? How do we solve this issue?
Right. I think we still have one more question about political hygiene for you, Debbie and Shakina. That was the first question from Calvin. How do you make sure that you get rid of the bad manners in political parties?
I would also say I don't have a definite answer for that, though I know there have been case laws where a person from one political party is campaigning for, I think, like the Aisha Jumwa case, if I'm right, and there's also more case. But from what I read, I've known the political parties whose member is misbehaving or who's campaigning for another political party, they can be taken to their dispute resolution tribunal. Yeah, so that's one of the suggestions I'll put. Or they could taken to their own political party's dispute tribunal or the political party's dispute tribunal, which is not, yes. And also I could say maybe the political parties could have provisions that ban such members from their parties. That is my opinion.
Thank you. Thank you. We could now give the floor to Jimmy to respond to Margaret's question.
Okay. If I got you right, Margaret, your question was on individual ownership of land and the compensation process. And I would like to answer this question with regards to what Mr. Kimeu had raised up on compulsory acquisition and unregistered lands. So particularly for individual ownership, there is a framework, and it's the Constitution, or rather, there are provisions under the Constitution by establishing what we call the National Land Commission. That is supposed to facilitate this process of compulsory acquisition for the government. So it follows up the due procedure that's highlighted under the National Land Commission Act and the compulsory acquisition processes, is that when particularly land, and particularly for big projects that have been brought up, there needs to be, and even at the Article 40 acknowledges that for unregistered lands and for individual lands, there needs to be a process to duly compensate. They are assured that right of compensation. But now, in terms of registration, the new constitutional dispensation, or rather how the 2010 constitution came into play, had brought three particular changes. And one of them was devolution of land governance. In that, we have the national government and removing the functions of registration and adjudication from the national government to the county governments to properly register lands, one, that are involved and specifically for community lands, and even for individual lands, there is a process, because now you'd find that letters were allotted to particular persons, but they never followed the due procedure of registering the land. So I'm rambling a bit. So to answer your question on individual ownership, yes, it is assured under the new constitutional dispensation, and due compensation is part of that particular framework. And I would like to point to one case, is the recent OGEC ruling by the African Charter on Human and People's Rights. And judgment was that the question that has always been brought into place is that this due compensation, what is the period and what is the implementation? Because we acknowledge that land has economic gain and economic factors. So what would we consider the appropriate time for compensation? And then what would amount to public purpose, even though we cannot strictly define public purpose? Ni nini hii shamba inatumika kwa ubinafsi wa wengi? Naelewa? I believe I've answered you. Have I?
Thank you. Thank you very much. I think we have a couple of minutes. If I counted the time we were given, we still have about 6 minutes or so to get another round of questions, maybe just one more round, then 3 questions. Then we see whether we have more time after that.
Pardon, Mr. Kimeu. Calvin had also asked questions on how do we enforce Article 39 and especially the right to reside for internationally displaced during political participation. So I'll first answer, how do we ensure enforcement of Article 39? My answer will be limited to the 2 arms of the government, the legislature and the judiciary. First of all, for the legislature, to repeal laws that restrict freedom of movement. Until now, we still have these archaic colonial laws that restrict freedom of movement. Like, for example, you could be arrested by the police for reasons such as loitering at night, and you haven't done anything. And this is from archaic colonial times and laws that were imposed by the colonialists to restrict our movement, and they're still being used to now. So the legislature needs to check on repealing those laws, and even for the laws that are now implementing the freedom of movement, they should check if they're being implemented, not just drafting. For example, let's talk about refugees. We have the Refugee Act of 2021, which now allows for integration of refugees into our communities, but this is just on paper, because now they have said that the refugees have right to freedom of movement, the right to work, but there are no business permits. They even allow the refugees to drop their refugee status and get their EAC citizenship, but there is no way of doing this. So actually implementing, not just drafting laws, but checking if this is being implemented. And as for the judiciary, they need to interpret Article 39 so that we can get civic education on what to do when our movement rights are being restricted, because most of us don't know all of this. We don't know that if our movement rights are being restricted, they have to be subject under Article 24. Yes. And if the judiciary can check this, then it is going to be easy for the executive to implement these laws. And as for the right to reside, especially people who you have mentioned, the internationally displaced persons. When I was presenting, I forgot to mention even the wordings of Article 39, where they say every citizen has the right to reside anywhere, just because, as I had explained before, we weren't allowed to even go to Nairobi. We had to carry permits. So this law was introduced so that there are no segregations. Ukitaka kuishi Nairobi saizi wewe unaweza enda kuishi Nairobi. Ukitaka kuishi Kakamega wewe uishi Kakamega. And even in the Meatball case, the Supreme Court reinstated this and said everyone has the right to reside anywhere. And the internationally displaced persons are considered as vulnerable communities under Article 21.3. So the state has right to address their needs. And I will prompt Jimmy to even give more about the right to reside anywhere as he's dealing with property rights.
Okay, rather to respond to that question is, I would focus on what we, on international law frameworks, on how to address this right. And it goes beyond even refugees, and because, okay, housing, residency, stay, registration of land, it's a socioeconomic right in its nature. Because how will you move around, how will you reside somewhere if you're not assured of a place to call your own, a home? So Bell tried to answer this question, but it did not effectively, because the court, how would I say, restricted itself in regards to interpreting, and particularly, restricted itself. Even you'd find that the definitions when they were trying to say what the drafters of the Constitution meant by international, general rules of international law, what would then be accepted for Kenya? So it's a matter of the courts trying to implement, because I believe the court has the reassures this right of residency and property in that regard. So when they were trying to understand and define what these international acceptable standards are, and particularly even with regards to Bell on social housing, on housing ownership, the question always comes up: what is the framework internationally? Then how we implement. And the particular conventions that I'd like to refer is the International Convention on Social and Economic Rights. It doesn't explicitly mention the issue of residency, but it does mention the issue of living standards. Understand? And residency does take what I'd call, does relate to that living standard. Where are you living? Are you situated in appropriate housing, even during, and this prompts me to talk about compulsory acquisition. When they're being moved, or when people are being moved to be duly compensated in the nature that they're being moved from one parcel of land to another, is that movement to that new residency addressing, is it effectively the appropriate living standard for those people, for such persons, even for internally displaced persons? And to answer a question that was raised to me on the political elite and what and the historical injustices of Kenya, as I stated before, I would like to state that there was the national cohesion. Let me refer for a minute. The national integration of 2008, section 13, of the post-election violence, it effectively forced this particular conversation on the historical injustices, because historical injustices, as I said, was willing buyer, willing seller. And if we acknowledge that the particularly the poverty situation that was in Kenya, not all communities could effectively gain or buy such land. So the conversation became both ethnic and colonial in a sense that we ignored the injustices. Now, the court's always left with the question of how do we address such injustices? And then I believe Article 46 particularly has come to land. How do we address? And the courts have tried to balance this in previous cases, such as Torino Enterprises versus the AG, petition number 5 of petition 5E06 of 2022, where it was found letters of allotment were given. Even with dinner management, it was found that this land belonged to the county government. Then the question is, how do we effectively how do we effectively address this injustice when the conversation is being censored around what I would call this historical injustice problem? And this injustice has even become, naweza sema donda sugu, kwa sababu imekuwa donda sugu in regards to what I would say is that registries, as up to now, they're also corrupt. Not corrupt. Not all registries are corrupt. Let me correct myself. Registries there are some registries that are found to have mischievous behavior, and this was highlighted in the Mavoko case rulings. How does this, the court did address this and found that there was illegally acquired land. Then the measures would be punitive, because this is what is defined under the Land Act, an illegal activity. The measures would be punitive in order to address that. But now the question of injustice is when and how will we address this? And the National Land Commission had started conversations as of this year, 2025 June. So I believe if we follow up and do keep the National Land Commission accountable, we can address these issues effectively. And the courts can help with the issue of residency, and we can try to address the issue of on political elites manipulating the conversation or the conversation being censored. Yes, I don't have anything else.
Thank you very much. I think our time is much spent unless I am guided otherwise. So what I propose to do is, with much apologies, basically not take any more questions, but to give our panelists basically 30 seconds each to do their final submissions, if I may use that word, and then we will come to a close. And I think we'll start in those final submissions with Victory, who didn't get a chance to respond to a question.
Good afternoon once again. I am Victory, and it's been a pleasure to help us discuss Article 41 on labor relations. I would welcome even a discussion, input outside the doors of this room. And I hope we gain insight more and more as we continue. Have a pleasant day.
Yes, we go to Hazel.
Good afternoon. Thank you for joining us in this insightful conversation about political rights, movement rights, labor rights, and land rights. I also welcome other insights about the right to freedom of movement and especially refugees. Thank you.
Yes, I think we could go to Debbie.
Good afternoon. I would also just like to appreciate you, and will also appreciate your input on what you think of these rights, because this is leading to writing a book. So your input will be appreciated and will be added to our papers. Thank you so much for coming.
Yes, Shakina.
Also, thank you so much for your questions, for your participation. It has made me think of my article in a deeper sense, like how do I address the issue of non-compliance with the IEBC? It's not something I thought of so intently. Thank you so much for your questions and for your participation.
And Jimmy?
To close this conversation, particularly in regards to my right, and I thank everyone for the contributions and the questions. Let's leave here with more questions. The conversation doesn't end here. And I would like your contributions. And yeah, I believe you're going to be really valuable. Thank you.
Thank you very much. And for me, I want to take this opportunity to just highlight one or two things that have come to mind as we were having this conversation. the questions that have been asked tell us one thing, that our constitution, our constitutional journey is work in progress. That, to borrow the words of Thomas Jefferson, the price of freedom or liberty is eternal vigilance. And I think we have a very progressive constitution, but one constitution that really requires that each and every one of us exercises vigilance and stands up to defend their rights and the rights of others as per the Constitution. And the areas that remain hazy are clearly going to be illuminated through litigation, research, and enforcement. And the challenges are many. The questions that Calvin has asked, the question that Margaret has asked, really have no very definite answer. They are a call to action that we all roll our sleeves and continue to defend our constitutional democracy. Now, secondly, I think there are, of course, issues of corruption, administrative failures and inefficiencies. The question of whether our political parties are political parties so-called, and many others that we can talk about, but time is not on our side. Kwa hivyo kwa sasa hivi ningependa kuwashukuru Jimmy, Victory, Hazel, na Shakina na Debbie kwa mchango wenu kufanikisha asubuhi ya leo, na pia ni washukuru washiriki ambao singeweza kuwaona kwa sababu ninashiriki kwa mtandao. Ni washukuru sana kwa kuhudhuria kikao hiki, na kwa sasa hivi ningependa tujipigie makofi na tupigie makofi panelists wetu kwa kufanikisha hii session ya leo. Na mwisho kabisa ni washukuru waandalizi wa haya mazungumzo na viongozi wa Chuo Kikuu cha Sheria cha Kabarak kwa nafasi, kwa mwaliko na nafasi ya kuweza kuchangia kwa namna hii ambayo nimeweza kuchangia adhuhuri hii ya leo. Kwa sasa hivi nawashukuru, asanteni sana. Tunaweza sasa kuelekezwa kwa mankuli ya mchana na wale ambao wanahusika. Asanteni.
Thank you very much, Mr. Kimeu. Please, let's clap for him. He's really guided this session. I want to just echo some of the things that he said, that there are certain things that don't have answers. But as well, I wanted to say that sometimes we take it very easy on our politicians. When a political party is crying that its member is campaigning for another political party, and they are the ones who have the members of parliament, and they can change the law so that they can eject the member, why should we be helping them as citizens? Isn't that a self-help issue? Yeah, yes. So when a political party is complaining at you, oh, what can you do? During finance bill, we were with senators in Mombasa, and they were telling us, oh, even us, we don't know what we can do. Business owners stood up and asked them, you are the government. How can you be crying and we are crying? So let's not take it easy on our political parties. They don't do their work. And what we should be doing is speaking with our votes. When we don't like what they do, you vote for another party. You don't vote for the same parties. I wanted to mention something about the land question. And I believe you are talking about compulsory acquisition and the exercise of eminent domain under Article 40. So I think under Article 42, it sets out the fact that there must be prompt and fair compensation based on the market price. So there is already a statement under Article 40 of the Constitution, when the government takes your land to do a project, that there should be fair and prompt compensation based on the market price. And the courts have been able to enforce this to state that the exercise of compulsory acquisition, when the state wants to take your land to build a road, serikali inataka kuchukua shamba yako kujenga barabara ama kuweka station ya stima, lazima ilipe kwanza kabla utoke kwa ardhi yako. Lazima ikupatie ardhi nyingine yenye ni ya value, yani yenye inagharimu pesa sawa na ile ambayo unaachilia, ama ikulipe kabla utoke kwa ardhi yako, kwa sababu hufai kutoka ardhi yako alafu kuwe mtu landless, homeless. So I think that question has been answered by the Constitution itself. It is also covered by the Land Act and by the rules, regulations under the Land Act. There are specific regulations in 2017. I think they're called the Acquisition of Land Regulations of 2017. Yes, so I know the ones who are asking are young. They'll meet me in 4th year. We shall talk about them a bit more. Okay, so now we go for lunch. We want to come back to the main hall at 2:30 for all 3 sessions. So we'll be doing 1 hour for every session from 2:30 to 3:30. We will be doing the first breakout room, 3:30 to 4:30, the second, 4:30 to 5:30, the third, so that we can participate in all the sessions and then wrap up together at 5:30. So we've had a good conference, give each other high fives and hugs, alafu run siku nyingine, si ndio? Alafu kesho, of course, ndio the inaugural Katiba Day. Tukumbuke kwamba imekuwa miaka 15 ya katiba hii, na tufikirie yale ambayo tumefanya hadi sasa na yale ambayo hatujaweza kutekeleza, na tujipe a program for implementation into the future, isn't it? So somebody has meal cards. Where is she? She's outside? Okay. So please collect a meal card. Proceed straight to the hall. You will notice that we are fewer. The other side has not finished, but we want to start exactly at 2:30. So kama mulienda high school kitambo kama mimi, kulikuwa na wale walikuwa nakula top layer. Kwa hivyo nyinyi ndio wale ambao mnapata ile chakula mzuri yenye iko bado na mafuta, wale tutawachia yale mabaki. Sawa? Kwa hivyo tukimbie. Nani atatuombea kwa maakuli? Sasa kuja tafadhali basi.
Good afternoon. My name is Mercy Makoham Nyangori, a finalist at Kabarak University Law School. So let's bow our heads for our word of prayer. Our dear Heavenly Father, I thank you for the fact that you have brought us since morning, and now it's noon. Oh Lord, I pray that you may bless us with wisdom, the knowledge and understanding for what we have been taught. And oh Lord, I also pray for the food and the hands that have prepared it. May you bless it, sanctify it, and let it nourish our bodies. And I pray that you may also sanctify our bodies, that it may not only be of service to you and also to others and our community. I pray, trusting and believing, and we all say, Amen.
Enjoy lunch. See you at 2:30 at Sawia Auditorium.